In early 2026, the world was hit with a data release of just staggering proportions, the Jeffrey Epstein Files. Today, we're going to break down what's inside, how it all happened, and what it really means for everyone involved.
So the number at the heart of all of this is 3 million. That's right, 3 million pages of documents that the U.S. Justice Department released, all tied to its decades-long investigation into Epstein. Now, just to put that into perspective, that is the largest release of evidence in a single criminal case ever. But the big question is, why now?
Well, the answer actually lies in a specific piece of law. You see, in late 2025, the U.S. Congress passed something called the Epstein Files Transparency Act. It was a bipartisan bill, and it was designed to do one thing: force the government's hand and finally bring the hidden details of this case out into the light.
So how did a story that started with a local police investigation in Florida blow up into a federally mandated disclosure that would shake governments and institutions all over the world? You know, the timeline really tells the story.
It all started pretty small, way back in 2005, but the case quickly became infamous for that controversial non-prosecution deal in 2008. After Epstein's arrest and death in 2019, and then the conviction of his associate Ghislaine Maxwell in 2021, public pressure for transparency just became unstoppable. And that all culminated in the 2025 law and the massive document release that we're digging into today.
So, what exactly is in this mountain of information? Well, the files are a really complex mix of legal documents, private communications, and financial records that together paint a pretty damning picture. Let's break down the contents.
We're talking about everything from internal FBI memos and interview summaries to personal emails and texts with some of the world's most powerful people. The files also include those notorious flight logs from Epstein's private jet and financial records that expose massive failures at major banks like JP Chase.
And you know, it's not just paper. The release includes a huge trove of multimedia evidence. We're talking over 2,000 videos and more than 180,000 images. Now, here's a crucial point. Authorities made sure to redact or withhold any material showing child sexual abuse. And that was to protect the victim's privacy, which is, of course, a key ethical consideration in a release this huge.
Now, what's really fascinating here is how the documents simplify the network's twisted logic. They reveal that the trafficking operation wasn't just run by one or two people. It was actually structured like a pyramid scheme, where victims themselves were manipulated into becoming recruiters.
And this just brilliantly illustrates that horrifying process. It was a three-step funnel. First, you had associates like Ghislaine Maxwell who would groom young girls. Then, Epstein would exploit them. And finally, those very same victims were paid to bring their friends and other girls into the exact same network, creating this self-perpetuating cycle of abuse. It's just awful.
The release of these details, well, it didn't just stay within U.S. borders. It immediately triggered a global political firestorm, implicating some of the most powerful people on the entire planet.
I mean, the list of names found in these files reads like a who's who of global power. You've got royalty, like the former Prince Andrew, past presidents like Donald Trump and Bill Clinton, tech titans like Bill Gates and Elon Musk, and politicians like Britain's Peter Mandelson.
But, and this is a really important but, context is everything here. It's absolutely vital to distinguish between the different types of mentions. On one hand, you have direct evidence like photos of Prince Andrew or flight logs confirming travel for people like Bill Clinton. But on the other hand, you have unverified FBI tips or emails that just talk about potential visits that may or may not have even happened.
And this brings us to a crucial point we have to make super clear. The mere inclusion of a name in these 3 million pages is not proof of wrongdoing. The documents contain everything from hard evidence to hearsay and gossip, and separating fact from these unsubstantiated claims is the massive task that journalists and investigators are facing right now.
The real-world consequences, though, have been swift and severe. In the UK, Lord Peter Mandelson resigned over financial ties that were revealed in the files, while King Charles evicted Prince Andrew from his royal residence after new photos came out, and a deeply racist email from a Norwegian diplomat to Epstein caused major diplomatic outrage in India.
This global fallout really raises a fundamental question about how different societies handle sensitive information. The Epstein disclosure puts that tension between public transparency and individual privacy rights into sharp focus, especially when you compare legal systems like those in the US and India.
It really makes you ask a critical question. When it comes to cases of sexual abuse, where do different democracies draw the line between the public's right to know and an individual's right to privacy? This chart here lays out the stark differences. In the US, you have Megan's Law, which makes sex offender registries public. In India, the equivalent database is private, only accessible to law enforcement. And it's similar with victims' identities. While US courts can unseal them in the public interest, Indian law strictly forbids it to protect survivors.
So, with 3 million pages now public, the immediate question is, what happens now? The thing is, this disclosure isn't the end of the story. In a lot of ways, it's really just the beginning of a long and difficult process. And there are significant challenges. Critics are quick to point out that heavy redactions are still hiding a lot of names. Some files are being withheld for ongoing investigations, which leaves big gaps in the narrative. And honestly, the sheer volume makes it incredibly difficult to verify every single claim, creating a really high risk for misinformation.
So what's the path forward? Well, experts seem to point to a three-pronged approach. First, strengthen anti-trafficking laws across the globe. Second, tighten up those banking regulations to cut off the money that fuels these networks. And third, increase international cooperation so offenders can't just escape justice by crossing a border.
Ultimately, the significance of this whole release is maybe best captured in this sentiment. For the survivors, many of whom were dismissed and disbelieved for decades, this disclosure is a powerful form of validation. It really is a historic moment where transparency is finally starting to pave the way for a deeper kind of justice.
And all of that leaves us with a critical question for our time. The Epstein case forces us to confront this difficult balance. As information flows instantly across borders, how do we design systems that hold the powerful accountable while still fiercely protecting the dignity and privacy of both victims and those who might be named without proof? It's a challenge we're all now forced to consider.